All right. So today, if we look at our table of contents, you'll notice that we're now through the 400s and we're moving in to the 500s. We have killed one block of the multi-state bar examination, which is relevancy and character. It makes up about a third of the bar exam. We're getting ready to talk about, for a moment, privileges, and then we're going to move into witnesses in general, the 600 series. Because the witnesses section makes up another third of the bar exam, which is impeachment. And then the final third of the bar exam is hearsay. You should be feeling pretty comfortable now, based upon what I've covered in class, if you're doing the multiple choice practice questions that I've suggested to you. Now here's the thing that I don't know, because I've never taught a tethered evidence section to primarily part-time students before. I don't know if your work schedules are allowing you to do the multiple choice questions. And I, of course, cannot make you do them. I can only tell you that it will make a phenomenal difference on your score if you do a good number of multiple choice questions. And if you are completely out of time, start with the Cali lessons that are available on the Cali website, and then work your way back towards any other secondary materials that you have. But you really need to do those. I can't emphasize it enough. I'll say it every day until you take the exam, and I know that you probably won't believe me, because you'll think that you're smarter than I am, which is probably true. It doesn't take much. But this is evidentiary law, and its applications are not like learning to dance or play a musical instrument. There's an element of it that is application, and there's an element of it that's theory. And if you don't do the theory through application, it just flat out doesn't stick. You won't remember it, and then I'll feel bad when you don't get the grade that you should have gotten in class. All right. Privileges in the United States. The privilege rules are the only rules in the evidentiary code that are designed to accomplish a different goal. All of the other rules are oriented towards maximizing admissibility of relevant evidence wherever possible, unless there is a policy reason not to let it in. The privilege rules start with another idea. They start with the idea that even though this evidence is relevant, even though this evidence would be helpful towards the ascertainment of whatever the truth actually is, we are, because of the unique nature of the source of the information, not going to allow the jury to hear it. And so privilege is a concept that is designed to remove relevant, useful evidence from the trial. So let's take, for example, a lawyer whose client tells him, I'm going to murder my wife. And then the wife is murdered. And the lawyer breaches attorney-client confidentiality and goes down and tells the cops, my client told me he was going to murder his wife. I didn't believe him, but she's dead, so I must have been wrong. That's a breach of confidentiality, which is an ethical standard that is completely separate from the evidentiary standard of privilege. Because even if confidentiality has been breached by the lawyer, the ability to assert the evidentiary privilege of attorney-client confidentiality as it relates to the privilege against the evidence being presented could be used to prevent the lawyer from testifying at trial. So the ethical rules that you learn work in concert with the evidentiary rules, and there may be some overlap, but they are a different standard and a different analysis. And I wanted to make sure that you understand that. And in fact, in the realm of attorneys and clients, you've got three things going on. You have attorney-client confidentiality, you have the attorney-client privilege at trial, and then you have attorney-client work product. Right? Why is this important to you? For the short term, it's not. Because I'll only ask you about privilege if I ask you at all. For the long term, and by long term I mean in the practice of law, is probably the most important thing for you to understand. The class that you probably enjoy least in law school, at least it's probably in your top 3, is professional responsibility. It depends on who taught it to you and the way in which it was taught. But for most folks, it's like, oh God, please don't make me go to Sunday school again. But the fact of the matter is, in the practice of law, it is the one class that you take in law school that you will apply each and every single day. It's the only one that applies every single day. There might be better ways to teach it, but it's not my job to resolve that particular issue. But this is one of those places where it interacts with privilege. In my mind, the privileges that I think you ought to understand are very basic common law privileges. The attorney-client privilege that we've talked about, the spousal privilege, and the marital privilege. And if I ask you about a privilege question, and I don't even know if I'm going to put it on the exam yet, those are the 3 that are most commonly asked on the bar exam. Why? Because first of all, you're all going to be attorneys and clients, and you sometimes confuse attorney-client confidentiality with attorney-client privilege. I can violate confidentiality as the lawyer, and that has an impact on my bar license. It has an impact on my ability to continue to be a member of the profession. But violating confidentiality does not mean that the jury hears the information, because that's a separate privilege analysis. And so I take this moment to sort of remind you of that in case it did not come up in your professional responsibility class. How many of you, when you took professional responsibility, heard a discussion about both the evidentiary rule, attorney work product, and attorney-client confidentiality when you talked about 1.6? Good, because you should, because those 3 are intertwined with one another. But that's the extent, really, of how I'm going to look at privileges on your multiple choice exam, because experience tells me that's really all you need to know from a bar perspective. Psychotherapist patient privilege might be useful to you as well, but I don't intend to test on that. And I just tell you that up front. It's Jaffe v. Redmond. It's interesting, but it's not that interesting. Now, the Florida rules of evidence are phenomenally different. Just as the federal rules of evidence rely solely upon the common law, the Florida rules of evidence outline in great detail all of the privileges that exist in the state of Florida. The reason that we don't have federal rules that are outlined in detail are because at the time of the passage of the federal rules of evidence, Watergate was going on, and the President of the United States had asserted executive privilege as a reason that he did not want to give up the tapes. And so this resulted in the Congress saying, we're not going to pass evidentiary statutes that might have some impact on that particular impasse with the executive branch of government. It's just an anomaly of the federal system. The Florida system is very detailed. If you're going to be a practicing Florida attorney and you're going to take the multi-state bar examination with the Florida section on evidence, they will ask you some sort of privilege question that's just kind of odd. For example, in the state of Florida, we have the accountant-client privilege. Think about that for a minute. You know, the conversations that you have with your accountant is privileged. You know, I can't see it at all. You know, I see why they've done it, because there's a good accountant's lobby, and there's a desire to protect that. But why do I point it out to you? Because there's a whole host of Florida-specific rules in this area. You've got them all in the materials for this particular class. It does not matter for the short term, but it will matter for the long term, so you've got that resource when you're studying for the bar exam. It's all there in one place. Those are the rules of privilege that I wanted to mention tonight. Does anybody have any questions about any of those privilege rules? Yes, ma'am.
I have a question, but you said that we need to agree attorney-client, spousal, and what was the third one?
Marital. The spousal marital one is the fun one, because it's spousal marital is like 609 for convictions, or it's like 408 and 409. It's one of these rules that turns on specific timelines and places and points, which means it's easy to write a difficult multiple choice question on those areas. And so the bar examiners like it all the time. Yes?
the communication that's protected in spousal and privilege, the difference is that marital privilege is only communication during marriage, so divorce will kill it.
Well, divorce kills it for any communication that happens. Think of it this way. Marriage is a great big ball with a semi-permeable barrier. And when you get married, you go through the wall of the ball, and you and your spouse are inside the ball. Anything you say in that ball is privileged. Unless you say it in a place that waives privilege. So if you're talking about how you murdered your next door neighbor on the subway, you've waived the privilege of the marital privilege because you're not having the communication in a private way. When you leave the marriage, either because one of you dies or because one of you gets kicked out, you split up, all the things that you said remain within that great big plastic ball. They don't come outside with you. And so they cannot be offered into evidence. It applies in both civil and criminal cases. And it only exists from the moment of marriage to the termination of the marriage. Spousal privilege is the much older privilege. And it applies to any communication between the couple that occurred even before marriage. And it exists throughout as long as you remain married. And if you divorce or your marriage is annulled, the privilege not only dies, but you can now go back into and pierce that earlier information. Spousal privilege historically was a right that was asserted by the party spouse, and by that I mean the person who was on trial, and it only applied in criminal cases. But the majority of federal jurisdictions have now shifted spousal privilege so that the non-party spouse has the ability to assert or not assert. This means the federal government has more of an opportunity to lean on the non-party spouse to see if they can get them to waive privilege and implicate their beloved.
So spousal privilege is only in the criminal?
Only in the criminal. If you'll think about it, when you line the two privileges up together, it becomes easy to see where they overlap and where they don't. Where they don't overlap is a prime area for multiple choice question asking, right? Because try to make it look like it's one thing when it's actually another. Reading comprehension always being part of multiple choice questions. Yes?
But it only covers communication, though.
Yes, communications between each other.
But does it cover what they saw or anything else?
Doesn't cover what they saw or observed. It's what they were told. So if, for example, she saw her husband run over somebody in the middle of the street, that's an observation. Although you would have a hard time finding out that because getting to that information as to what was seen might be difficult. Because you probably have an assertion of privilege that you would then try to get around to establish that privilege does not apply. And that becomes a factual query, yes.
I'm sorry, I don't want to belabor the point.
You can beat the horse to death, I don't care.
So if I'm in a criminal proceeding and a spouse, well, they're former spouses, so there's a divorce, but there was something that was said when they were married, I can pierce that privilege because they're no longer married?
No, if I'm in a criminal proceeding and it's the spousal privilege,
Yes.
a communication that occurred during the marriage,
Yes.
I can't necessarily pierce it.
But they're divorced.
Doesn't matter.
I thought you said when they're
I thought you
divorced.
said when they're divorced, you can pierce it.
No, I'm sorry. Marital privilege, I couldn't pierce.
Right.
Spousal privilege, I couldn't.
Okay.
Yeah, I was thinking marital as opposed to spousal, yes.
Thank you.
But then couldn't you still not be able to pierce it even if they're claiming spousal privilege if it was during marriage because it implies the marital privilege if we were in a criminal case?
Well, the difference is that spousal privilege can be let me put this. The difference is that marital privilege can be asserted by either party. Spousal privilege The majority rule now is that only the non-party spouse, so the person who's not been indicted, is the person who has to assert the privilege. So there is a difference in analysis of who can decide whether or not to pierce the privilege to make the information available. So you have to identify, if you're analyzing it, if it's a communication before marriage occurred, what is the only privilege that might apply? Spousal. If it's a communication that occurred during the marriage, which privilege can apply? Both. If it's a privilege that occurs after the marriage is terminated, is there a privilege? No. What about while the marriage is still ongoing and we're at trial? Well, if I'm at a criminal trial and it's spousal privilege, i.e., it's something I said to my spouse before we got married, then my spouse gets to decide whether or not to waive the privilege. If, on the other hand, it's something I said to my spouse after we got married, then both of us can assert the privilege. So what's the teaching point for you? If you're going to engage in criminal activity and tell your beloved, do not tell them until you put a ring on it. Because you have the greatest ability to keep them from testifying against you if you only make the disclosure after you're married. Because if you make the disclosure before you're married and then marry them to keep them quiet, you have just shifted the balance of power in the relationship for all eternity. And he or she will make you do whatever they want, because there will be the overwhelming threat of disclosure if you don't make them happy, which is how spouses who marry people who have killed people often wind up killed themselves. Because at some point the person who's done it before thinks, hey, this is just not working out. And the only way I can keep you quiet is to keep you quiet. All right? Yeah, I want you to think of spousal and marital privilege in much the way you think of 609, and in much the way you think of 408 and 409. It's one of those areas that's just, it's kind of technical, but it's helpful for you as law students to be able to analyze it correctly. The 609 one comes up commonly at trial. The other two, quite frankly, don't come up that often. They usually come up during the pretrial process as you're trying to sort out what the case is worth or how you're going to present it. Let's talk about competency of witnesses for a moment. Look at this. In a civil case, state law governs the witness's competency regarding a claim or defense for which state law supplies the rule of decision. So if I've got a civil case with a particular cause of action, and in that particular cause of action, whether or not a witness is competent is defined by that state statute, that would be the rule that would hold. Which means, for example, cases against handicapped folks in jurisdictions where handicapped individuals are allowed to testify without taking the oath, as long as they reach a minimum level of, on the Wunderlich intelligence scale, would be acceptable, right? If that state has that statute. It means that the only real way that I could throw some bizarre competency question at you would be to give you a state statute with a standard for competency that was off base. And where does that most often happen? It most often happens when dealing with someone who is of diminished capacity, either because of a mental disease or defect, what was commonly referred to in the Supreme Court as retardation in the Supreme Court jurisprudence, someone who's autistic, phasic, people who have communications difficulties are examples of where you might have that. For example, in the state of Florida, children can testify and are deemed competent and do not have to take the oath to tell the truth. In the federal system, a child has to promise to tell the truth. Although the inquiry by the judge to ascertain whether or not they understand truth could be different. I mean, you have a judge say, do you understand the difference between telling the truth and telling a lie or telling a fib. Yes, I do. What's a lie? What's when you say something that isn't so? What is it okay to lie? Yes or no? Well, why or why not? That could be a sufficient inquiry to establish the competency of the child to testify without having them taking the oath in the federal system. You know, they don't have to raise their hand and say, I swear, you promise in the case now I'm hearing to give evidence that is true, the whole truth, and nothing but the truth, so help you God. No, you don't have to say that. It's also why we say swear or affirm in the federal system when we give the oath. Because you're either swearing under your concept of a higher deity, or you are affirming as a member of our society that you will be truthful. And either one is sufficient from an oath and competency perspective. I think that that's interesting. I'm talking about this, and I've got 509 on the thing. I'm sorry, guys. Everybody's looking at me like, Professor Rose, what the hell are you talking about? I wear a size 15 ring. You have to remind me when I drag that hand across the thing and I don't realize it.
It was that for a while.
It was. It's like sausages on the end of your hands. Imagine. It's really just pitiful, and I understand that. I think it's one of the reasons that I frighten people so badly. Are you still frightened? Not anymore, right? But remember back when class started, you were frightened. Yeah, you're now in on the secret. You're not frightened anymore. Yeah, I've been busted. Any questions about competency? Yes, in the back.
What's the dead man statute? Do you know that, or is that not apply?
I am not going to ask you a question about the dead man statute as it applies to competency. I will not. And that's sort of my general rule as we talk about these federal rules of evidence. There are a host of things that I could ask you deep in the comments of each rule, but I am not doing that. I am testing your competency of the application of the rule in real life settings. I'm doing that for a couple of reasons. One, because you've been taught it that way, but number two, that because that's the way the bar tests it. They see evidence as one of those aspects of the bar examination that has a procedural component to it, that tests your application of the law in the moment of the practice of law. And the bar exam is not looking for fewer opportunities to do that, but more opportunities to do that. They're trying to push competency and procedure into the bar exam. It's why they're looking to move civil procedure into the multi-state bar exam. It's why they ask questions about presumptions and instructions and that stuff, because they're trying to say that they're more practice ready as they work you folks to the bone. I think it plays right into the wheelhouse of what you get taught here at Stetson, not so much at other law schools. Yes?
I have a quick clarification.
Sure.
For the last couple words, where it says which state law supplies the rule of this decision, does that mean if it's a state law claim?
If it's a state law claim in federal court such that state interpretations of competency would apply. Yeah, so it's a very narrow category, but it's there to make it clear that because states define competency differently than the federal government does on some causes of action. To either broaden the base of potential plaintiffs because they're trying to prevent certain types of harm to the community, or to narrow where they think that it's been inappropriately applied. So you just got to look at the statute.
Okay, so if it's a state law claim and in that claim it defines competency,
You'd have to apply that standard.
It's not all state law.
It's not all state law, no. It's got to be specific to the claim. So you can see how it's very narrow, but they put it in the rule to make certain that it's clear. Let's look at Rule 602. I should think of 602 in concert with 702, 703, and 704. There's two ways that a witness testifies at trial. One way is that they have personal knowledge, even if it's personal knowledge of a hearsay statement that's otherwise admissible. And the other is if they're giving an opinion, either a lay opinion that's rationally based or an expert opinion. But the personal knowledge requirement is how we get relevancy of the witness's testimony. And evidence must be introduced sufficient to support a finding that the witness has personal knowledge of the matter. And it doesn't need to be anything more than the witness's own testimony to establish personal knowledge. That should tell you now, oh, when I ask certain background questions and foundation questions, like a headline to set up a line of inquiry, I'm establishing the personal knowledge of the witness as to the issue about which they're going to speak. And without personal knowledge, they're not competent to testify. And personal knowledge becomes a component of the foundation that I lay during direct examination of the testimony of witness. That's one reason that when I say objection, lack of personal knowledge, I could also potentially do objection, lack of foundation. Sometimes I could do both. Objection, lack of foundation, they've not established personal knowledge. Because those two run through Rule 602. Any questions about 602? Yes?
Can you make inferences to establish the personal knowledge, or do you have to get the witness to say something really specific? I'm just trying to think of an example. Like, can you say, like, can I pretty much testify to anything, like, about the relationship between my mom and my dad?
No. Because there's some things I would hope that you don't know about your mom and dad's relationship.
But things that wouldn't be that nature. Just if I testify that I'm their child, is that...
I don't think saying that their child is sufficient. Let's say you want to talk about your mom and dad's financial affairs, because that's some issue at a trial somewhere. I would have to lay the foundation that you had knowledge of their financial affairs. So I might say, I would like to talk to you about your mother and father's financial affairs. Did your father ever speak to you about how he managed money in the family? Did your mother ever speak to you about how they managed money in the family? What was your understanding of money management as it existed between your mother and your father? I would ask those questions. Now that sounds like background information, right? But I'm also laying the foundation for your personal knowledge of the fact that I want to admit through your testimony that's necessary to my case. If you'll think about it, all the background information that we taught you in direct examination, headline, I'd like to talk with you about, where were you at that time, what did you see, what did you do, those all lay the foundations to establish personal knowledge. And the foundation to establish personal knowledge to some extent comes from the senses, what you saw, heard, taste, smelt, felt. All of those are potential ways in which I can establish the foundation of knowledge. Now, what personal knowledge doesn't give me is personal knowledge of what someone else did at another time. But I can have personal knowledge of what someone else said. So I take my personal knowledge of what I heard them say, I connect it to a hearsay, exclusion or exception, and then I use the testimony of the witness testifying about their personal knowledge of what they heard the other person say to admit it substantively because there's a hearsay exception. And that's how witnesses can testify about things that other folks told them that they don't themselves have personal knowledge. So when you hear someone ask the question, what did they tell you? Objection, lack of personal knowledge is not a good objection. Objection, hearsay is a good objection. Yes?
I guess I'm thinking about this, and I don't have this, I can't find it in front of me, but for making a layperson's opinion about something.
Hold it till we get to 701 and we'll talk about it then.
That's where I was wondering if...
We'll talk about it then, because theoretically, lay opinion sort of requires some element of personal knowledge in order for it to be valid. And they talk about a rational basis for the opinion. And rational basis implies some degree of personal knowledge. It's sort of like, hey, the car was going 55 miles an hour, that sort of thing.
That's where I came with the parent and child.
Exactly. We'll get to that one in a minute. But that's an opinion as opposed to a factual opinion. A factual testimony, which is slightly different. Any other questions about 602? Cool, good, all right. You should just remember, if the witness can't take the oath, in other words, they don't understand the duty to tell the truth, if they can't be understood, then they're not qualified to testify. Now that can't be understood as a phenomenally broad category. And we have folks who are autistic, who routinely testify at trial, who you or I could not understand. We have people speak in foreign languages with an interpreter, and that is perfectly acceptable. We have folks speak in sign language with an interpreter, and that's perfectly acceptable. We even have folks who have been allowed to testify using certain tactile sensory devices where the person will hold their hand and they'll supposedly move a stylus and spell out words. Yeah, I have the same reaction to it that you do. I'm like, hey, wait a minute, this sounds a little creepy to me, and that I'm not sure it's valid. But courts have allowed that. So this issue of capable of communicating becomes a two-pronged question sometimes. Both do they have the ability to communicate, and if they're communicating through a third party, is that third party qualified to make that translation? And if it's someone who's a translator from a language perspective, they take an oath and you establish competency. If it's someone who's using a mechanical device or some other type of training, that becomes problematic. When you look at 603, you should now think of it in terms of ability to observe, recall, relate. You know, our common law ability to impeach goes to the ability to observe, recall, and relate. It's got to be extreme for the witness to be disqualified, but it can be less than extreme for the witness to be discredited. So there's a connection for you between observe, recall, and relate and one of the federal rules of evidence that you may or may not have seen before when we did impeachment, but I pointed out to you now. Any questions about 603? I'm getting the feeling that y'all are getting bored. Maybe I should give you some problems or something with that. Somebody laughed out loud. Okay. I'm just watching a couple of you fall asleep. It's that point in the year, isn't it? It's just that point in the year. Oh, you've got taxes, right? How many more days have you got? 6 more days? She said that with gritted teeth.
Final trial is the 15th, final tax day is the 15th, and then I'll be so much nicer.
I'm not going to ask how your personal life's going right now. You know, because I know. I find that my beloved wife knows exactly when I'm experiencing the most stress at work, because it is then that she strikes with the request. With the request that I could easily deal with if I was functioning at full capacity. Because she doesn't really want me to do it. She just wants to point out to me that I am running on fumes. To get me to stop. Not that she did that today at all. Okay, Rule 604, interpreters, right? Qualified to be an interpreter should be a what rule question? A 104 question for the judge, right? The judge makes a determination as to the qualifications of a witness. So a judge, based upon curriculum vitae, the fact that they've been used as an interpreter by the court before, or that they're a native speaker of the language, could be more than sufficient. I used to routinely bring German nationals who worked in my office, in the claims department or whatever, to come in and translate for German witnesses at trial. I'd lay the foundation that they were a native-speaking German, and then they would promise to truthfully translate, and away we'd go. It is a miserable experience to direct or cross a witness through a translator. Those of you, just take what you're doing now and multiply it by about a factor of 10, and the frustration level can become extreme. Particularly if you have another lawyer who thinks they speak the language and then wants to get into an argument with a translator about whether or not they're interpreting properly. Which happens here in our jurisdiction quite frequently with the Spanish language. Yes?
Well, one of the biggest problems with interpretation is sometimes it's interpreting a concept versus a word. So like sometimes when I try to translate things from English to pure English, like one word might not translate perfectly, even though that might be a similar word, but you try to translate the idea, you might have to substitute words to change things because you don't translate the entire concept.
I'll give you a classic example. Morgenstunde hat Gold in Munde. It's German. It means the early bird catches the worm. That's what it means. It translates to the early morning hours put money in your mouth. So, I mean, you're absolutely right. Concepts are more difficult. But here's the thing, folks. I shouldn't have a witness who's testifying based upon personal knowledge about colloquial meanings. Because if they're doing that, then I'm trying to get an opinion through them. I'm trying to get a summation of what they thought they saw, as opposed to factually relating what they represented. So if I structure the direct examination or the cross-examination properly, I don't run into those issues. But it's absolutely true. That's where you run into them. Idioms are how you identify someone as a non-native speaker long after they've been speaking the language. And that even happens, how many of you have been to the United Kingdom? Have you run into the idioms that the English use that make no sense?
I'm English, so I use them, and
Yeah.
everybody else notices them sometimes.
Well, I mean, when someone says banger to me, I think of something completely different from sausages. That's, what, bangers and mash?
Yeah.
That's sausage and potatoes. Tea time is sort of, I think, like supper, like lunch.
It's kind of like 4:30.
It's like 4:30, and we call it supper in Alabama, or dinner, and it's tea time. But if you take a break in the morning, that's not tea time.
Tea time is the time you go to the golf course.
So this idiom stuff is kind of fascinating, but it doesn't really matter for us. Interpreters qualified by the judge under 104 and oath or affirmation to make a true translation. Any questions about 604? Cool, good. Don't really want to talk about the judge's competency as a witness. Let me just, guys, in the federal system, the judge does not testify. If the judge testifies, the judge is no longer the judge, he's a witness.
I asked my attorney how this came to be. How did this become an issue? I mean, when would you want? It just didn't seem sense to have that in a rule.
In the state, a judge can testify as to ministerial matters in the trial that they are overseeing. I can't find case law that gives me an example of it, but it's in the Florida statute. That's kind of odd, right? That's also a difference between Florida and federal. And remember what I've told you. Where those differences exist is where you most often have questions. Juris Competency as a witness, I'm not going to ask you about that. Jurors don't testify at trial. If they're testifying at trial, they're no longer a juror, they're a witness. Where might a juror testify? If post-trial there is an allegation of jury tampering or racial, gender discrimination, something of that nature that skewed the deliberations of the jury. And that's literally the only time we pierce the veil of deliberations. And the only way that happens is if one of the jury members, sua sponte, raises it to the court. Because we don't even ask the court. We don't even ask the jury about how that happens. Because once you begin to litigate the deliberative process of the jury, you have destroyed the finality of verdict. And you think people don't want to be on jury service now. Imagine if afterwards they could potentially be sued for the way in which they deliberated. It just wouldn't happen. It wouldn't happen. There's got to be a magic box somewhere that everything gets poured into and the answer comes out of. The magic box for us is the jury room. I read a very interesting article recently. Did any of you see the article about where a physicist has posited that each of our physical bodies is nothing more than a reception unit for our consciousness, and that the consciousness actually resides in a portion of your brain? And they can now see that when a person dies, that particular energy leaves that portion of the brain and goes somewhere. It's a fascinating idea, because they may have literally seen an electromagnetic or a quantum energy representation of the human soul. Just something to think about. I don't know why that popped into my head. I think it popped in my head because I read the article and I thought, well, that's really cool. Impeachment. How many of you have taken a jurisprudence class here at the law school? How many of you think that the source of the validity of the rule of law matters? Where do you think the rule of law comes from? You know that historically the entire concept of the rule of law comes from a concept of God? That the idea initially was that man's law on earth was a reflection of a higher power's law in heaven. And the validity of the law was in its comparison to the religious law. And then this thing called the Enlightenment came along, and we began to pull the two apart. And the interesting thing is, once you remove from law a religious concept as to why it is valid universally, where do you find its universal power to be applied? And that is the philosophical question of the 20th and the 21st century. Some people say that it comes from the people. I don't know about you, but I've seen what the people do on Facebook, and I don't think it comes from the people. But I'm happy to entertain ideas about it. Impeachment. Remember, we can impeach our own witnesses. We do not vouch. There is no voucher rule in either the state or the federal system. And I can put a witness on the stand and impeach them with impeachable information with one caveat. I cannot put a witness on the stand for the sole purpose of impeachment. They must have some information that is relevant to the cause of action, some evidence that will move the scale ever so slightly one way or the other under a logical relevancy theory. I can't put them on just to destroy their credibility. First of all, because we don't want lawyers to play games with witnesses like they're mice or bugs. Secondly, because it doesn't help the process from a justice perspective to have that happen. So just remember that from an impeachment perspective. Any questions about who may impeach? Yes, ma'am.
As far as, if you're impeaching your own witness and you're directing witness, you're still not able to use evidence because they're still doing that examination, but how do you go to impeach them?
Give me just, okay, well, we'll just go to that rule now. Mode and order of examining witnesses and presenting evidence, Rule 611. We didn't talk about 611 in our evidence class to any great degree, but 611 was mentioned in multiple places in the reading in your trial ad book. It's right there in the piece where we talked about direct examination. It's there when we talk about cross-examination. 611 establishes a couple of things for us. The first one is that it gives the judge the discretion to determine how questioning should be conducted. So the judge rules one way or the other. And the judge can allow me to ask leading questions as opposed to open-ended questions if the situation so calls. So for example, when I have a witness that I've called on direct examination, then I begin to confront them about something that's an impeachable issue, and I want to use closed-ended questions. I start to ask closed-ended questions. Objection leading. Your Honor, I'm going to impeach the witness, and impeachment is properly conducted in a leading fashion. Judge may sustain it, it may not. If the judge doesn't sustain the objection, I just continue. If the judge sustains it, now I've got an issue. I've got to do what? Lay the foundation of the rule to show that the witness is hostile so that I'm allowed to lead. For example, a fact pattern that I've used multiple times in class, you've got a 14-year-old girl on the witness stand. She claims to have been a rape victim. She's now recanted, and you called her as the prosecutor during your case in chief. The young woman is hostile to your case. She has identified someone other than the original accused as the perpetrator. It's an unknown person, but she's recanted all of her allegations and has refused to cooperate with the government in preparation for the trial. Can I put her on the stand and immediately begin to cross-examine her? No. I've got to establish the hostility under 611, which is relatively easy to do. Same thing with the mother of that child. If I call her during the state's case in chief, we're not in a friendly relationship. She is hostile to the government. I just have to establish that through some foundational questions. Ma'am, are you happy to be here today? Well, you know I'm not. Why is that? Because you're trying to railroad my husband, and I've told you multiple times that I'm not going to stand for this. In fact, I refuse to talk to you. Your Honor, we ask you to be allowed to treat the witness as hostile. The judge will just say, well, yes, she is. And then away you go, because what has that just done? That has shifted the rule. So that where normally on direct, I would be allowed only to ask open-ended questions, because the witness is hostile to me, I can now ask cross-examination questions. It also means that on cross-examination, the counsel that would normally ask leading questions should, in all fairness, only be allowed to ask open-ended questions. I know it's a little bit of a mind twist, but we should be at the point now in the evidence class where we can see that. Let's make it even easier. This is a question from the multi-state bar examination within the last 2 years. Plaintiff is on the stand during direct examination of the defense's case in chief, which means the plaintiff has been called by who? The defense. Is the defense counsel allowed to lead the plaintiff? Yes. Because just by nature of the fact that it's the plaintiff in a civil action being called in the defense's case in chief, what is that plaintiff? Directly adverse to the defense. By the same token, on cross-examination, the plaintiff's counsel should only be allowed to ask open-ended questions. Why do I point this out to you? Because that's counterintuitive when you read the rule. Because you have to read 611 in light of the circumstances of who's testifying, what they're testifying about, and who's questioning them. Why do I point this out to you? Because the National Conference for Bar Examiners is in love with this type of question right now. And they will set it up so that it's twisty, and then you have to untangle it to make certain that the party who's asking leading questions should be allowed to ask leading questions. Make it a little bit more complicated for you, because I always can, right? If you're laying foundations, you're allowed to lead with either witness. If it's a witness that leading questions would assist in being able to testify, let's think, folks, of diminished capacity now. Someone who has a mental disease or defect, or someone who by virtue of their age or sophistication needs to be led to the question. Judges will routinely allow for leading questions of autistic children or young children on direct examination. Routinely. When you have an adult that has a mental disease or defect that gives them the equivalent of a child's age, so that they are less sophisticated than they appear, the judge will allow for that sort of thing. And 611A gives the judge all that sort of control, because they're looking at avoiding wasting time and protecting the witness from harassment or undue embarrassment. But that being said, we do define and affirmatively give power to lead during cross-examination. And so they outline in 611B the scope of cross, but what you don't see up here is 611 open-ended questions for direct examination. So where does that come from? That comes from custom and practice. The idea being that if the witness is testifying from their own personal knowledge, under 602, leading questions are not designed to get out the personal knowledge of the witness. They're designed to test the validity of what the witness has or has not already said. And that's how we actually wind up with open-ended questions on direct examination. This is the sort of questions that come up out of 611. And if you look at the end of it, ordinarily the court should allow leading questions on cross-examination and when a party calls a hostile witness an adverse party, or a witness identified with an adverse party. So there's 3 different ways that I can potentially have that sort of issue that comes into play. I wanted to ask you guys at this point in the semester, has having the book in a digital format been helpful at all for any of you? It has been worthwhile from a highlighting perspective. I like not only the highlighting, but the fact that I can put comments in and type them in. It's one of the reasons that I like it in the iBooks format, the ebook format, as opposed to the other. Because in Kindle you don't have that same ability, although they've upgraded it recently. Okay. 611 is a pure procedural format rule that I have until today never really talked about in class, because the only way that I can test it is exactly like I've just talked about, by flipping the parties, flipping the situation, to see if you can identify whether they should be allowed to direct or whether they should be allowed to lead. Now, I've told you that those sorts of questions have shown up on bar examinations recently. So you probably expect that I may ask you 1 or 2 of them. You all, as Stetson tethered evidence students, should have no problem uncorking that. And in fact, those questions on my test usually have an extremely high equivalency, which means that they're valid questions and most everybody gets them right. So you don't want to be the one who misses it, because you're just sort of digging yourself a hole, right? Questions about 611? All right, good. Let's look at a couple more before we call it a night tonight. Any of you have 4-hour trials tonight where you got to play witness or show up for something? No? Okay. All right, good. How many of you are done with your 4-hour trials? Doesn't it feel good? Yeah, it feels great, doesn't it? It's like awesome. If you have Judge Demers group, you're usually the last ones to get done. Usually the last ones. No, I cannot. You don't want me as a witness. I make people cry. I make people cry. Okay, we talked about impeachment, who may impeach. Let's look at character for truthfulness or untruthfulness again. What is the only way of impeachment where I cannot offer extrinsic evidence to prove the underlying factual basis for the impeachment? What is the only one? Say it.
608.
Say it.
A witness's character.
All right. Everybody say it. Character for truthfulness. No extrinsic evidence. I'm not kidding. Say it out loud. Character for truthfulness equals no extrinsic evidence. Say it again. Character for truthfulness equals no extrinsic evidence. Half of you will miss those questions on the bar exam, on the test. I'm telling you right now. You will forget, and I will trick you. And then when you come for your exam review, we will laugh together about it. You may laugh silently, but we will laugh together. Why is character for truthfulness, why do we not allow extrinsic evidence? What's the thought process behind it?
It focuses the trial on something that it shouldn't be focused on.
It's a collateral matter. It is literally a collateral matter. I want you to think about that for a moment. The truthfulness of a witness is a collateral matter at a trial. I think that's funny. Because the whole idea is built around taking the oath and the witness being truthful. So is it really because it's a collateral matter, or because it gets so doggone confusing when we start having a trial within a trial within a trial that the jury can't sort it out? I think it's the latter. It's not that it's not important, it's that it's just too hard. And so we're going to call it collateral. But that's the answer. It's a collateral matter. Truthfulness is collateral. When it deals with character for truthfulness, or a specific act that indicates a character for truthfulness. Here's the problem. Sometimes the act in question may be indicative of character for truthfulness, or it may be indicative of motive and bias to lie for or against the party. That line between character for truthfulness and motive and bias to lie or prejudice to lie in favor of one party or another is a very important line. Because if I'm in motive, prejudice, bias to lie, motive to lie, can I offer extrinsic evidence? You bet I can. Because prejudice and bias is never collateral. But if it's a character issue, just a character trait for truthfulness, it's collateral. This means that the way in which I set up the cross-examination of the impeachment when I'm dealing with a character issue needs to be clear. It also means that if I'm smart, I don't put together an impeachment under 608 and follow it up with an impeachment on bias, motive to lie. Because they get conflated in the minds of the jury, they get conflated in the minds of the judge. And the judge may shut me down and not let me put in the evidence of prejudice and motive to lie. That's a very interesting practice point from and actually doing it. It's also a very interesting point evidentially, because it means you've got to read with specificity and make the judgment call. Is this a 608 impeachment, or is this a bias, prejudice, motive to lie impeachment?
Which is common law.
Which is common law, does not exist in the rule, but is routinely used. And you can argue that bias and motive to lie is a logical or a legal relevancy question, right? But it's not in 608 in the federal rules. Now, in the jurisdiction where I tried a lot of cases in the military rules of evidence, there's a 608C, bias, motive to lie, that clearly defines it and also says that you can offer extrinsic evidence for it. But you don't have it in the federal rule. They've just left it to the common law. It's an interesting place where I can get an overlap between 608 and a common law theory of impeachment, and so I pointed out to you. And remember, character for truthfulness is only relevant after the witness is what? Testified. But if I go after character for truthfulness, either to say that they're truthful or to say that they're untruthful, it's not yet relevant. And if it's character saying that they're truthful, it's improper bolstering because their credibility has not yet been attacked. So there's a nice little timeline there, right? Of bolstering, of improper bolstering and the like, which makes it very easy for me to create a set of circumstances where you've got to be able to apply all of those to sort them out, which means it's a target-rich environment from a multiple choice question perspective. Yes?
So if you have a witness and they impeach on truthfulness, you can, if that's your witness, you can then bring in evidence of truthfulness of that witness.
You would bring in a reputation and opinion testimony. You bring in people to say that they're a truthful person, to argue that that impeachment was not valid, or it should not cause them to be less credible at trial. And if you'll think about it for a minute, it's really brilliant, because the idea is we don't want to waste any more time at trial than we have to. So these issues may become relevant at trial, or they may not become relevant at trial, depending upon the factual circumstances of the witness and the tactical decisions that the lawyers make. Which means that I can drive a trial in many different directions if I properly understand how impeachment works. And I can build my case theory around different ways of going after witnesses if I properly understand how impeachment works. Now I'm going to stop here tonight with 608. We'll pick up with 609 tomorrow, and then we'll move into 701, 702, 703, and 704, which means that we should finish experts tomorrow, meaning that we've really got nothing left to talk about next week other than hearsay, which we just the heck did, and some foundation and other minor stuff. Any questions? Yes?
Everyone can, this isn't about class necessarily, but it is an evidence question. How would you enter, like someone calls someone and leaves them a voicemail, how would you get a voicemail into, it's not for my 4-hour trial, I promise.
If it's a voicemail, if I have someone who recognizes the voice of the person on the phone, someone who has personal knowledge of the way they sound, I would call that witness to establish personal knowledge and have them verify that it's a personal statement. Just like I do with handwriting.
What about if at the beginning of the voicemail, it does that thing where it says message from number 678?
Well, if they know the phone number, that only establishes the number that it came from, doesn't necessarily establish the person on the phone. All right? See you guys tomorrow night.